So now moving on to the IR35 case of George Mantides Limited. Mr. Mantides was a locum urologist and therefore was working gigs at different hospitals, no commitment to stay beyond the end of a particular term, and therefore, whilst his contracts were more than for a day at a time, they were nevertheless discrete engagements which had no guarantee of being continued. The Revenue took issue with two of his engagements, a 6-month engagement at the Royal Berkshire Hospital and a 2-month engagement immediately afterwards at the Medway Maritime Hospital. The first tier found that the 2-month contract at Medway was outside IR35, but the 6-month contract at the Royal Berkshire Hospital was within IR35. And neither side was happy with the result. Both sides were unhappy with the side that they had lost. Now, whilst a lot of the cases I'm dealing with today involve employment status, there is a second theme which will be emerging from these cases, is if you're unhappy with a decision, you've got to make sure you appeal in time. George Mantides Limited appealed against the First Tier Tribunal's decision in respect of the point which it was unhappy with, Royal Berkshire Hospital. HMRC apparently appealed against the decision to the extent that it went against them, the 2-month stint at Medway Maritime, but they were too late to do so. So the upper tribunal only looked at the Royal Berkshire Hospital, the 6-month stint. Now, the Revenue not only were late and rejected by the first tier, but they sought permission from the upper tribunal at 2 further stages. They asked for it on paper, and then they were still unhappy with it. They went to the upper tribunal to an oral hearing saying, please, can we have permission? My view is that if you've been rejected because you are too late, the upper tribunal is very rarely going to look behind that unless there was a decision, unless the first tier, when refusing you on the grounds of lateness, has somehow acted in an inappropriate fashion. But obviously the Revenue were pretty keen to get the point decided. Now, I should add, there is actually a dispute, in my view, as to whether HMRC needed permission to appeal against the bit they were unhappy with. But that's a separate point, and that relates to a bit of case law called SSE generation, as to what you do if you're unhappy with part of a decision. That's a whole separate question. But for present purposes, all we need to worry about is that if you're unhappy, appeal in time. Secondly, this case concerned only the company's appeal in relation to the 6-month period. Now, there were 4 grounds on which GML sought permission. The first 2 were appeals against the findings of fact which the company was unhappy with. Now, generally, you cannot appeal against findings of fact because the First Tier Tribunal is the only place in which facts are found. However, if the first tier reaches a finding of fact which it cannot justify on the basis of the evidence before it, then that is treated as an error of law, and the upper tribunal will entertain such findings of fact. And what the taxpayer was arguing here was that the 2 of the factual conclusions reached by the first tier were inconsistent with the evidence found, and it was effectively amounted to the First Tier Tribunal making up assumptions as to what the facts were, rather than actually deciding the case before it. The first finding that it didn't like was a finding that the parties were required to give a week's notice of the end of the assignment. The second finding of fact was that the doctor would make reasonable endeavours to work 10 half-day sessions. In other words, the First Tier Tribunal reached its conclusion on the basis that the doctor was signed up had to give a week's notice if he ever wanted to terminate the relationship. Otherwise, it would be an ongoing relationship. And in a particular working week, was required, or at least to try to work 10 half-day sessions, which is effectively a full working week. Those are the first two grounds of appeal. The third ground was that George Mantides Limited argued that the first tier had wrongly analysed the contracts involved, and in particular the hypothetical contract that you need to look at when dealing with IL-35. And fourthly, failed to apply particular case law correctly. So those are the four grounds of appeal which the taxpayer had got permission to appeal on. By the time that the taxpayer's skeleton argument reached the upper tribunal, which is usually about 2 weeks before the hearing, it looked as if the taxpayer wanted to expand the grounds of appeal by saying, well, actually, I also don't like the fact that I don't think that the other terms of the relationship with the Royal Berkshire Hospital are consistent with employment. In other words, it was trying to run the third test of ready mixed concrete by saying, look, take a step back. Are these facts consistent with there being an employment relationship? And it would have been quite useful to have the upper tribunal grappling with how does that third ready mixed concrete test work? How does one draw this picture if one does draw the picture? Unfortunately, and this is, as I said, a constant theme in these cases today, it was all very well raising the point in the skeleton argument, but permission hadn't been granted, and 2 weeks before the hearing is a little bit late. Now, the taxpayer responded to this saying, well, wait a moment, before the first tier tribunal, George Mantides Limited was not represented by a lawyer. I think it was Mr. Mantides himself was taking the case. Therefore, show a bit of flexibility for the fact that it was a litigant in person. The upper tribunal was broadly sympathetic with that line of argument, but pointed out that actually they'd had counsel for a year before the hearing, and therefore there was plenty of time for counsel to have pointed out that actually there are additional grounds that need to be raised, and they should have raised them at that much earlier stage. So I think what the appeal tribunal was saying is, even though permission hadn't initially been granted by the first tier on the point, the upper tribunal would have considered expanding the case to deal with ready mixed concrete test number 3, had there been sufficient notice given. But 2 weeks before the hearing, even for a litigator in person, I think is cutting it a bit fine. They weren't going to give permission to extend the case. It's a shame that we didn't get ready mixed concrete looked at again. A very similar issue arose in the Northern Light Solutions case a few months ago, another IL-35 case, where the taxpayer wanted to raise ready mixed concrete 3 at a late stage and was not given permission to do so. So far as the other extension of the case, the company wanted to argue that the second ground, the reasonable endeavours test, had led to a wrong conclusion on mutuality of obligations. Now, on that point, the upper tribunal said, yes, you can argue it. We think it was actually implicit in ground 2 anyway, but for the sake of formality, we're going to allow you to argue the impact of mutuality of obligations on this reasonable endeavours test. So how did the upper tribunal deal with these 4 grounds of appeal? Ground 1 and 2, it actually agreed with the taxpayer that there wasn't any sufficient evidence for the first tier tribunal to reach the findings it did. It said the evidence was unclear, but there wasn't anything to support this effective guess by the first tier tribunal. The tribunal said, I don't know what the contract is, I am going to assume. And that assumption was held to be an inappropriate finding of fact by the first tier tribunal, and therefore the first tier tribunal's decision on the facts could not remain. That meant that the upper tribunal was then required to consider whether or not the hypothetical contract had been analysed wrongly, and in particular, how did mutuality of obligations fit in. But the upper tribunal didn't actually decide that point. It said, we're going to hold back pending PG Mole. So either there'll be another hearing in due course in this, or we might have to see whether PG Mole goes up to the Supreme Court or what happens to that case before we get a final decision in George Mantidis. We've got some developments, but not necessarily all the information we need. And as far as the fourth ground of appeal, the upper tribunal didn't really understand it, said we can't quite understand what this point is. It seems to be covered by grounds 1 and 2, which we've allowed. So a partial success for the taxpayer. The question is, how is that going to help when the hypothetical contract is dealt with? Now we have a case here. I know there are other tests re IR35, but seeking to provide 10 half-day sessions a week should be tantamount to full-time employment. I think the answer to that is that the commitment to provide 10 half-day sessions a week is no longer a valid finding, and therefore what would be tantamount to full-time employment is no longer a relevant consideration. I think I'd also point out that committing yourself to provide to work full-time for a week, I don't think that necessarily makes one an employee. I think you could still be self-employed even if you're providing your services for 40 hours in 1 week. It's just one contract of many. But that ultimately is for either the first tier, if the case goes back to the first tier, or the upper tribunal to consider all the facts in the round, applying the Hall and Loam approach, which I think is still good law, but we might have to wait until after February to find out. I'll now move on to the Wilson case. And this was a case involving a member of an LLP. I think I have to emphasize it was a very junior member of an LLP. Mr. Wilson was working with a large to medium-sized firm of accountants, which had 2 classes of member within the LLP structure. It had the management members, who were clearly, in my view, the owners of the business. And then you had a class of members called the client members, who effectively were subject to the direction of the management members, and in my view, look very much like senior members of staff rather than owners. Now, when Mr. Wilson came along, he was initially made a client member, so this junior member of junior category, but actually then lost even those rights that the client members had. He lost some of his right to information. He had a fixed profit share, or a guaranteed income of £180,000, provided that the firm made profits during the year. So if it made a loss, he wasn't entitled to anything. But once it made £1 worth of profits, then he was entitled to 180,000 each year. He also was entitled to a share in the profits of the international tax practice. But it would be not totally wrong to describe him as a senior member of staff with a fixed salary, a profit share, and not much more. HMRC determined him to be self-employed for tax and national insurance purposes. Mr. Wilson was claiming to be an employee, presumably because he wanted the tax to be accounted for by the LLP and not out of his own pocket. And there is a background to this case that it looks as if he might be in dispute with the accountants. So that's why he wants them to be saddled with the tax. The case went to the first tier tribunal, who agreed with HMRC. that he was in fact self-employed for tax and national insurance purposes, and the upper tribunal agreed with the first tier, but not necessarily for the reasons. Now, the case is particularly interesting because it considers the interpretation of certain provisions relevant to LLPs. Now, I'd be interested to know what your own experience is of this particular provision. It's section 863 of Itoya. But this reads, subsection 1, for income tax purposes, if an LLP carries on trade professional business with a view to a profit, all the activities of the LLP are treated as carried on by partnership, by its members, and not by the LLP. And anything done by or to or in relation to the LLP is treated as done by members or partners. And the property of the LLP is treated as held by the members, as if it were partnership property. And this is generally interpreted as saying, if you are a member of an LLP, you will be taxed as a self-employed partner rather than as an employee. And the reason why this is significant is because when it comes to ordinary traditional partnerships, i.e. those governed by the 1890 Partnerships Act, not the incorporated form we have under LLPs, when you're dealing with that type of scenario, the revenue will make a very clear distinction between equity partners and salaried partners and say, if you are a salaried partner, for example, you're entitled to a fixed salary, then even though you call yourself a partner, you will be taxed as an employee, and therefore the partnership would have to account for PAY national insurance as if you were an employee. Even though you're holding yourself out to be a partner and you might be sued, you will nevertheless be taxed as an employee. Now, what that means is that ultimately what the revenue has to do, or the taxpayers have to do in an ordinary partnership, is decide, well, even though I'm calling myself a partner, am I really a partner, or am I really a salaried partner, in which case I'm really subject to, I'm an employee and therefore subject to PAYE. Whereas in the LLP world, no such investigation needs to take place. If you are a member of an LLP, then you are treated as a partner. All the activities of the LLP are treated as carried on in partnership by its members, not a subclass of members, but by its members. In other words, there is a general assumption, as I've always understood, that section 863 is determinative. Now, what did the first tier say? Well, there were arguments. If you read the decision, it seemed to suggest that 863 was determinative in the way I've just explained, and was the way I've understood it always to have been assumed. However, the taxpayer argued that 863 is not determinative, and possibly even more interestingly, the revenue didn't seem to argue that section 863 is determinative. And there were suggestions that one has to look at the substance of the relationship. Now, my personal view, but I'd be interested to see what others think in due course. My personal view is that I think 863 is in fact determinative in all cases where there is a genuine membership of an LLP. It doesn't matter what the rights are, but as long as it is not a sham membership, then just merely once one calls oneself a member of an LLP, and that is and you generally mean to be called a member of an LLP, you're not sort of someone signing you up without your knowledge, etc., then there doesn't have to be much substance to the rights as an LLP. That's a contractual matter for the other members to decide. But once you are de facto a member of an LLP, then I do think that Section 863 is determinative. It could be that the revenue agrees with that, and the only reason they say it's not determinative is because they want to rule out those sham cases. I would be interested to know what other people have thought about that, and maybe during the break you can comment, if you'd like, on what your experiences are on that. But the upper tribunal had to grapple with the question: did the first tier tribunal consider 863 to be determinative, or was it dependent on there being substance? Well, as it happens, the upper tribunal didn't grapple with the question, because third ground of appeal was a challenge against the first tier's finding that the individual was in substance a partner. There was enough substance to the relationship to amount to being a member of an LLP and therefore not being an employee. So the first ground of appeal was treated as academic because the substantive question for the upper tribunal to look at was whether or not there was in substance Mr. Wilson had partnership rights. I'll look at ground 2 first and then carry on with ground 3. Ground 2 was looking at another statutory provision, section 4.4 of the Limited Liability Partnerships Act 2000. And here there are conflicting areas of case law. We have a Court of Appeal that considered this and said, and a Supreme Court which suggested, but only obiter, that the Court of Appeal had got it wrong. What this provision says is a member of an LLP shall not be regarded for any purposes as employed by the limited liability partnership unless if he and the other members were partners in a partnership. He would be regarded for that purpose as employed by the partnership. And what the Court of Appeal noted was, well, if you are a partner in a partnership, let's look at the condition at the end. If you're a partner in a partnership, you cannot be employed. So that unless bit is meaningless, and therefore the provision would make much more sense if it said a member of an LLP shall not be regarded for any purpose as employed by the LLP, full stop. The Court of Appeal said, well, Parliament wouldn't have come up with a completely meaningless provision. Therefore, it tried to invent some sort of test so as to make some sort of sense of what Parliament has said. The Supreme Court, however, in a case called Clyde & Co. and Bakes van Binkhoff, said what the Court of Appeal had forgotten is that the LLP Act applies in Scotland, and in Scotland, partnerships they're a separate legal entity from the members. And therefore, there is still an open question as to whether you can be both a partner in Scotland and an employee of that partnership. And therefore, all Section 4.4 is doing is addressing that possibility and protecting the law for the outcome of that question in due course. Now, what had happened was the first tier tribunal had decided that the Supreme Court had overridden what the Court of Appeal had said on Section 4.4. Because what the Court of Appeal said was only obiter and not part of its ratio, strictly speaking, the first tier should have taken on board what the Court of Appeal had said and not what the Supreme Court had said. So there was a challenge as to whether or not the first tier tribunal had followed the wrong bit of law. But like with the Section 863 point, the upper tribunal said this is an academic point. We don't need to address it. The whole question is whether or not there was substance to Mr. Wilson's partnership status. What he had tried to argue is that it had all been hollowed out. So ground 3, was he in substance a partner? And continuing my sub-theme of the day, actually all Mr. Wilson had been given permission to appeal on was the fact that he objected to the first tier using some of the labels which the parties had used in some of the contractual terminology, and wrongly being guided by these labels. What Mr. Wilson argued was that the first tier had said, signed up to be a client member, and client members are clearly members with sufficient rights in the LLP, and therefore would be treated as partners or members of the LLP and not as employees. And Mr. Wilson was arguing that the first tier had focused its mind on the fact that he was a client member and used that to cloud its judgment when analysing his rights. Well, the upper tribunal said, I don't think the first tier did make that mistake. It would have been a mistake had it done so, but it didn't make that mistake. When reading the decision, there's no evidence that it got distracted by the labels. But the upper tribunal allowed Mr. Wilson to make a wider challenge to the substance of his relationship by looking at other aspects of the relationship. As I said, he hadn't been given permission to do so, and therefore it was an indulgence of the upper tribunal. But the upper tribunal thought they could be addressed fairly easily based upon the information already before the tribunal. It didn't require new evidence to be added, etc. Therefore, in the interest of fairness, it agreed to deal with the new arguments. So looking at the overall substance, the upper tribunal pointed out that he did get some share of the profits of international tax, and he was interested in the overall performance of the LLP, because if the LLP made an overall accounting loss, he would end up with nothing for that year. So there were sufficient reasons for Mr. Wilson to be interested and have an actual substantive interest in the partnership position, or the LLP position. And therefore, whilst a lot of his rights had been hollowed out, to use the terminology that the taxpayer was advancing, it was not a completely absent, empty relationship, and therefore the first tier was entitled to reach the conclusion that Mr. Wilson was equivalent to a partner and therefore self-employed. What Mr. Wilson also tried to do is to argue the point not from the perspective of a partnership, but actually to go straight into the ready-mix concrete tests, apply the three-stage test from ready-mix concrete. And what the upper tribunal said was that was not appropriate. You first have to consider whether or not he is a partner or in substance a member of the LLP. So there's almost one minor exception to the ready-mix concrete being the standard test, but it's only in the context of this partnership relationship. Obviously, if you're not a partner, then the next question is, are you an employee? But that is a separate matter. Just to deal with some comments made in relation to the question as to the status of Section 863, David has made some very interesting points here. A traditional partnership is a relationship which can be hard to determine, of course, because you don't have to register a partnership. The relationship exists whether you know it or not, whereas an LLP has to be registered. So the fact of an LLP is a clear black and white point. So there's a clear distinction between members and non-members. I don't see why the section should not be determinative. So I think that David is agreeing with my provisional view, pointing out a potential exception, which is again consistent with how I understood it worked. By analogy, currently helping a client trying to escape from an abusive family who discovered that he is apparently subscribed for shares in family company that he knew nothing about. So official records are not determinative. Therefore, the right to test whether the putative LLP member was actually a member, but nature of the membership shouldn't matter. In other words, I think what David is saying, and I'm certainly reading it in the way that I think it works, is that virtually all cases, the fact you are signed up is determinative of the question, except in the circumstances where there is some sort of underhand dealings going on, such as fabricated records. I see that David has raised a hand. David, do I need to unmute you?
Oh, yes, I was if I'd understood you correctly, I was trying to agree with you. I think it's just it doesn't give you very many characters in the question space, so you've got to spread things out.
I agree with Keith Fitz, but yes, no, thank you very much, David.